Welcome to the Minnesota Judicial Center, an oral argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is February 12th, 2024. The argument is being live streamed, and we'd ask that you speak loudly and clearly and during your respective arguments. We have one oral argument today. Our file number WC 23-6536, Terri Beste versus Centracare Health Long Prairie and SFM Mutual Insurance Company. We have a three-judge panel today. I am Tom Christensen. On to my left, your right is Judge Kathy Carlson, and to my right and to your left is Judge Sean Quinn. Counsel have 15 minutes to make their oral argument. A yellow light will come on and give you warning of 2 minutes remaining. It's up to each of you to keep track of your time. Please be aware we've changed the rule a little bit now that questions from the panel can be expected anytime after you begin your oral argument. We both have very experienced counsel today, and we would only ask that after you step to the podium, please identify yourself and the party you represent. Ms. McCashin, I believe you are the appellant, so please begin. Thank you.
If it please the court, counsel, my name is Deanna McCashin. I represent the injured worker, Terri Beste. This matter comes before this court based on two basic topics. The first one is a legal issue, and that is the finding made by the trial court that as of 3 months after the first surgery, no further treatment, no further restrictions, no further anything into the future related to the admitted left shoulder injury. The problem with that finding is that at no time, up and including the day of the hearing, had the employer and insurer denied liability for the left shoulder condition. At the time of the hearing, they were still paying temporary partial disability as she was still working for this employer. There is no compelling reason that I can think of that caused the trial court to find that as of February of 2021, which was 3 months after her first surgery, that her left shoulder work injury had completely healed.
Ms. McCashin,
Sure.
I'll interrupt you at that point. When I look at the statement of the issues as outlined by Judge Bateson and that both of you had agreed upon, one of the issues was specifically, has the medical treatment the employer received for the left shoulder, et cetera, related to the work injuries, the claimed injuries. And Judge Bateson did answer those questions in his findings. Do you agree with that? That question was before him and he answered it.
I disagree with that. In the up until the day of hearing, all medical treatment to the left shoulder had been admitted and paid. She had requested pre-authorization. It was all paid. The only thing was medical treatment into the future.
Okay. And then issue number 4, kind of the same question. Does the employee need work restrictions as a result of her alleged work injuries from February of 2022 and July of 2022? And again, the judge answered that in his findings by saying she had no restrictions related to the left shoulder. Do you agree with that? Because it seems like these issues were presented and they were answered by the judge appropriately. You seem to say that he somehow expanded the issues, and that's what I'm not understanding your argument.
And the reason that I say that is because if you look at the opening statements made by counsel for the defense, is they were not challenging any past medical treatment for her left shoulder, only future medical. They're trying to say that as of the day of hearing, she no longer needed to have restrictions or medical treatment for the admitted left shoulder. Instead, the judge went back and made a finding that she didn't need any of the treatment all the way back to right after the first surgery. And if you look at the date, and I think the date is important, February 15th, I believe it, or February 19th, 2021. She was seen by her surgeon on the February 15th, 4 days before that. She was getting worse, her range of motion was decreased. She hadn't gone back to basic. And the employer insurer recognized that. They kept paying her temporary total, temporary partial. There was no.
And we've looked at the records that you're referring to, but let's stick to kind of the legal issue before we kind of dig into that. You said that all medical treatment related to the shoulder had been paid at the time of the hearing, so there were no outstanding bills at issue
Related
to the shoulder.
to the left shoulder, the thoracic outlet and the cervical, they were still out there.
Okay. So my next question then, if there were no outstanding bills related to the shoulder, has SFM tried to recoup any monies paid to your client or any medical provider because of the findings of Judge Bateson?
That would be information after the hearing, and I'm not privy to that. My understanding is that when you apply the principles that are used, if an employer and insurer decide to raise the issue after admitting liability and paying for treatment and wage loss, if they want to raise the issue, oops, maybe we shouldn't have done that. For example, based on their first defense medical exam, they could have done that, but they didn't give notice to us. There was no notice before we went to this hearing. In fact, it was never argued at the hearing.
But you did have, and I'm going to say Dr. W, and I don't mean that to be disrespectful or lazy, but just to not embarrass myself and everybody in the room. But you had Dr. W's report well before the hearing, right? So you knew of that opinion.
We knew that that report came out on September 9th. Even with that report, they pre-approved the second surgery. It was never asserted, and I'm saying that's an affirmative defense. If you want to say we've paid under mistake of fact, or something's changed, they certainly can do that, but they never raised it. If you look at opening arguments made by defense counsel, he was arguing that the reason she was having restrictions and wage loss was not due to her left shoulder injury. It was due to the cervical condition and the thoracic outlet, which they had denied primary liability on. He was basically arguing that in the future, they should not be responsible, essentially that it's no longer a substantial contributing cause of her wage loss. No medical bill had ever been denied for her left shoulder as of the day of hearing.
So what's the harm, though? And I don't mean to be flippant about it, but all the medical and wage loss related to the shoulder paid through the date of the hearing. Judge Bateson issues a decision saying, the shoulder is resolved as of this rather arbitrary date picked by Dr. W. Okay. Because one of the things you just said was Judge Bateson said no more treatment, no more restrictions related to the shoulder and into the future. He didn't say and into the future. I mean, unless I missed it.
He did say that her left shoulder work injury had resolved as of that date.
I think Dr. W said that, and Bateson adopted his opinion, but I mean, he didn't say it was a temporary injury. He didn't use that word. She had surgery, admitted, paid for, and still admitted and paid for, even with these findings, you got a client with a permanent, because it was cut open, permanent shoulder injury, I think that's still there. You have to prove that whatever future care or wage loss or whatever comes from that, but I still think you have that.
But you have to recognize the fact that this shoulder injury was not analyzed by the trial court based on the legal analysis that we all do when we have a work injury which has an element of degenerative change in it. Now, in this particular case, Ms. Beste had never been treated for, had complaints of anything with her left shoulder.
Right.
So if a work injury causes those degenerative changes to become a part of her work injury, it's there, and that has to be solved before we get to the point which the judge found it was all better. It wasn't all better. She never returned to baseline, ever.
Well,
To date, she still isn't.
It seems like, from reading the record, that and it wasn't February 15, but it was around April when she first saw Dr. McCarty, that all of the care from and after that date seems to be related to thoracic outlet.
Right.
And not necessarily the shoulder joint, the AC joint itself. I mean, and so, and Dr. W and Dr. Simonet both say that's not related. Judge Bateson adopted that. So thoracic outlet, not covered, shoulder joint, covered. I mean, you see what I'm getting at? It seems like the shoulder
Problem
treatment
is
isn't
that
there anymore.
Before the date the judge says, okay, it's all better, the surgeon, Dr. Edgerton, had referred her on to a shoulder specialist.
Dr. McCarty.
And he dealt with her shoulder.
Right.
And all the things that were part of her shoulder, which included the degenerative changes which were damaged during this work injury. So to arbitrarily cut that off and then not analyze thoracic outlet syndrome and then the second injury seems like a real injustice. And to do it without notice to the injured worker that they were taking a position that, oops, I guess we could have stopped caring for you 2 years ago.
But you had that report, and you had Dr. Simonet's report, which said there wasn't even any injuries at all.
But what I had from Dr. W, I'll call him that if that helps, what he said, as I understand it, is that the work injury aggravated, accelerated beyond the normal, the underlying degenerative changes. And
Right.
he never
And caused the need for the surgery.
Right.
Right.
And that was true for the second surgery. They paid for the second surgery even after he wrote that report. And so why would the employee, why would Ms. Beste think, okay, now they're denying any further treatment? I mean, they were pre-approving it. They paid for it. Treatment parameters say you paid for it. You can't come back and say, we don't have to pay for that.
Counsel, how is this case different from Kohler, the case that you had before this court in 2019? Because to me, the issue seems exactly on point.
They are not anywhere similar in terms of the factual background. Ms. Kohler, I think it was 8 years, maybe 10 years before the first work injury, and she had a whole bunch of injuries to her neck and her low back and different employers, same employer, same insurer, or multiple insurers rather. But she had treated, I think, 8 or 10 years on an ongoing regular basis with a chiropractor in Alexandria for those complaints. And it was already diagnosed a degenerative disc disease for her back and neck. So that was there, and it was ongoing right up until she had the work injuries. It seems like a game of words when you say, well, he never said it was temporary. Well, if he says it's all better as of February 2021, well, then it's all better. I mean, why would she need medical care? That makes no sense to me from just a logical.
Well, in the sense that, and this is how I have molded in my head, which is the sense of, it seems like it's all better. And then a year goes by, 2 years go by, it rears its ugly head again. I mean, that happens all the time.
But
And so that's how I put it together.
But if you look at it, the progression and all the medical records, and I do one of these flow charts so I can see where it goes. She never stopped treating. And up to the time of the hearing, she had significant restrictions on her left shoulder as a result of both surgeries, which they paid for and admitted. How can that not be an ongoing injury? That's where I'm losing the connection.
And my thought is, it seems like the defense doctors are saying, to the extent that she has restrictions, they're not related to the shoulder itself, but to this thoracic outlet, which they find to be not related. So that's the way I see it.
Well, I think Dr. Semonette basically said she never got hurt.
Well,
And
he did say that.
Their basic understanding of the work injury they lack foundation. I mean, Semonette talks about her reaching and flipping it over her shoulder onto the cart. How is that not rotational? My time is up.
Yeah, you said, I want to give you a chance to finish. You said there were two topics, and one was this legal topic, which we've been using up all your time on. What's your other one?
The other one was the factual background to this case. If you look at it, Ms. Beste had no medical treatment of any kind for almost 30 years for her neck. She knew, she's a nurse, she knew she had a bulging disc when she had the whiplash injury back in the 80s. So when she went to a doctor, she told him that history. That's a good thing to do. Doctors need to know what's in the background. There is no evidence of ongoing restrictions. I mean, there is nothing, not a single medical record where it says she's getting treatment for her neck in 30 years. And yet there is no analysis of what happened in 2022 when she was helping with the patient that had memory issues. It's just the same with the thoracic outlet. She had never had thoracic outlet type symptoms, and they were there from day one if you look at the first reports of injury. She wrote out all of the typical findings you see in thoracic outlet on her first report of injury. They didn't use that one. They sent a different one in, if you look at my exhibit, and said she's got a left shoulder injury.
Well, counsel, something that I've been thinking about these findings in order is it a choice of expert type of case, or is it more of the employee has failed to meet her burden? Because you're talking about lack of treatment, kind of a lack of explanation for it, yet there is nothing in the employee's medical records or by way of a narrative report that provides a good explanation either for the thoracic outlet or the cervical condition. So is your issue more with the burden aspect of it or with the choice of expert aspect?
When you have a pattern here where they're approving medical treatment as we go along, and then you look at what her three doctors, she has Dr. Edgerton, who did the first surgery, Dr. McCarty, who did the second, and Dr. Hunt, well, there's actually four. When you look at all of their records, they all say this is an aggravation of her pre-existing but asymptomatic conditions.
But is there any evidence that they had a full factual background of the mechanism injury and the entire history as what was provided to the IME doctors?
I cited that in my brief. She testified to it, that she told it. If you look at the QRC records, again cited in my brief, she sent them the records. She sent them the scans. They had all of the background. They had necessary foundation.
Thank you, Ms.
Thank you.
Cashman. Mr. Michelated. And so you're aware, there was 3 minutes and 37 seconds of extra time, so we'll give you that
That's just fine,
additional
Your Honor.
time
Thank
as
you.
well.
Your Honor, Nicholas Micheletti, appearing on behalf of the employer and insurer Centracare Long Prairie, and SFM. May it please the court, counsel. The employer and insurer maintain that this is simply a hengamule and Matic type decision, that substantial evidence, of which in this case there was a lot of evidence, lots of records, supports the decisions and the findings of compensation judge Bateson. This is a complex case from the standpoint that there were a lot of medical records, a lot of body parts to address, 2 dates of injury. So I'll try to do my best to support Judge Bateson's findings.
Let me ask you, I didn't ask Ms. McCash, but I'm going to ask you, this underlying left shoulder condition is what? It seems to be, to me in looking at the records, degenerative or arthritic condition, and that in terms of what Dr. Wojo indicated, had resolved as of middle of February 2021. Is that the right condition that I should be looking at, or is there some other left shoulder condition that I missed along the way in my review?
No, Your Honor, I think you've kind of hit the nail on the head, which is that there was something going on in this Ms. Beste's shoulder. What exactly is it? Is it a degenerative condition? Is it this Buford syndrome, which the employee testified at trial that she was diagnosed with? That's a condition where the rotator cuff does not grow all the way around. So when they initially took the MRI of the employee's left shoulder, it's noted as a possible tear. When Dr. Edgerton performed his first surgery, he went in there and found, oh, there is no tearing. She's got this Buford syndrome, which results in a lack of a complete rotator cuff, as well as thickening of the rotator cuff. So what he actually did was to address some degenerative changes that were evident in the left shoulder during that first surgery, and to actually thin out that rotator cuff thickening that was part of that pre-existing condition. Now, I think Dr. Wojo's opinion was that whatever happened during that first state of injury caused an aggravation of that condition, whether it's the degeneration or the Buford syndrome, such that that first surgery was reasonable, necessary, and causally related to the first work injury. But that following that surgery, which was very minimal in nature, that aggravation of the degenerative condition had resolved.
What he said was, these typically resolve in 3 months, and then he just randomly picked 3 months later. As Ms. McCashin said, there was a visit 4 days before that, where the doc says something to the effect of, looks like she's got some adhesive capsulitis still ongoing on, I'm going to order some therapy.
Mm-hmm.
And again, I know your client already paid for it anyway, but it seems like just saying something typically resolves in 3 months, therefore it resolved in 3 months, without looking at the records, saying, where's the date when it really resolved, if at all, seems rather arbitrary.
Taking it out of that context, I agree, it does seem arbitrary. But as we mentioned in this case, we've got a lot of different body parts, we've got a lot of things going on. So contemporaneously with the shoulder condition, Ms. Beste begins complaining of other things and treating for other things. And her complaints meander from one part of the shoulder to a different part of the shoulder, down the upper extremity into other body parts. And I think Judge Bateson, knowing that Dr. W had an opportunity to see all those records, to evaluate the scans, determined that, okay, this isn't an ongoing problem. Whatever she's got going on right now, which at that point was subjective in nature, was relative to something other than that work aggravation to her shoulder.
Sure, but that right now was 2 years later, when the trial was taking place. And, it just seems like that date troubles me, just February 19, just because. But I'm going to ask you about something else. The judge finds the employee completely credible, except for her comments about whether Dr. Simonet did certain tests during the exam, but otherwise credible. So, and one of the things she said was, well, after this was after the second injury, I got an appointment in a couple of months or a couple of weeks. I'll just wait then. I'm hurting, but I'll just wait 2 weeks. That's fine. And then in his memorandum, Judge Bateson says, well, if she was really hurting, she would have gone to the doctors right away, which if he found her credible, you would think he would have accepted that. And I don't know what your thoughts are on that.
I agree with the inconsistency there, Your Honor. Because to be honest, there were parts of Ms. Beste's testimony that I did not find credible, particularly with respect to the testing performed by Dr. Simonet. And then also at hearing, one of the things that she testified to was a brand new mechanism of injury for this second date of injury. So for the first time, despite our hundreds of pages of medical records, despite the fact that she had been deposed specifically about how these various injuries occurred, she testifies for the first time that this 94-pound elderly woman grabbed her behind the neck. You're not going to find any description of that to her various doctors, even Dr. Hunt, who examined her for her cervical spine. He makes no mention of that specifically occurring or how that mechanism of injury could have caused an aggravation of her pre-existing degenerative condition in her spine. So I know he goes out of his way to say that she was credible and then says this doesn't add up. But I think that the weight of the evidence, the records show that her testimony at hearing was not accurate.
Mr. Micheletti, this is kind of a housekeeping thing, and I asked Ms. McCashin the same thing. All medical treatment for the left shoulder and all of the wage loss benefits for the left shoulder were paid through this decision. Is that correct, or were there some outstanding benefits related to the shoulder?
Your Honor, nothing was paid following the hearing. So all benefits, wage loss, medical were paid prior to the hearing.
Okay.
So,
and has your client, sorry to cut you off, has your client done anything to recoup any benefits related to the shoulder paid prior to this decision?
No, Your Honor.
Okay.
The position of the employer and insurer is that those benefits were paid essentially under a mistake of fact. Ms. McCashin argued initially that the employer and insurer at no point denied primary liability for these conditions. That's simply not true. We had a 239 conference relative to Dr. W's report. We also had a 239 conference relative to Dr. Simonet's report, where the employer and insurer specifically maintained that not only did the employee not sustain injuries in the form of thoracic outlet syndrome and to her cervical spine, but also that she did not sustain an injury to her left shoulder. Following that 239 decision, the employer and insurer filed a petition to discontinue, which was consolidated with the claim petition. So not only was that a specific issue which we agreed upon at the hearing, but it was also part of a pleading specifically consolidated with what we were addressing at the time of the hearing as well. And I do want to point out in the hearing transcript, on page 147 of that transcript, Ms. McCashin says, the employer and insurer are denying that she's had an injury, a permanent injury, as a result of the 2020 injury. So it's a little confusing to see in her brief now that she's asserting that the employer and insurer never denied primary liability when she admitted at the hearing that that was in fact the case.
Yeah, it would seem to me, and looking at the two reports, one from Dr. W and one from Dr. Simonet, Dr. W indicated that there was an injury to the, sprain to the shoulder in the first injury, and Dr. Simonet reported in neither dates of injury were there any injury, and that seemed to be rejected by Judge Bateson, and he found that there was at least the first injury was sustained and was compensable. Does that meet with your understanding of Judge Bateson's findings?
Yes, Your Honor. It's my understanding that Judge Bateson adopted the opinions of Dr. W with respect to the left shoulder, but adopted the opinions of both doctors, including Dr. Simonet, with respect to the thoracic outlet and the cervical spine and the remaining body parts. Um, One particular note, Your Honor, with respect to the foundation of the various opinions that we have in this case. We've got an employee with these meandering complaints, various body parts, but the doctors that provide the most support, particularly for the thoracic outlet and the cervical spine, are very lacking in their foundation. Not only do they not describe the various objective tests that were done and how they affect their treatment recommendations, they also don't describe the employee's anatomical variation in the form of that Buford syndrome, which could theoretically significantly affect somebody with that condition in her left shoulder. Further, neither Dr. Karimi nor Dr. Hunt provide any explanation as to the mechanism of injury and how it could have caused either the injuries to the shoulder, the thoracic outlet, or the neck. If you look at those records specifically, they're very brief, and in both instances, the employee is seen by Dr. Karimi and Dr. Hunt for one time, and that's when surgery is recommended. The reports are very brief and limited in nature, and we don't know what they saw as far as the EMG scan ruling out neurogenic thoracic outlet syndrome, which I think is an important fact here. Dr. Simonet, in particular, does a good job of describing the mechanism of injury and how she was holding her hands and how she lifted up on the patient at the time that the alleged left shoulder injury or left shoulder injury occurred. Now, he's of the opinion that didn't or couldn't cause the type of injury that the employee had, but of course, Dr. W's opinions were ultimately adopted. The employer and insurer specifically also maintain that Dr. Hunt is incorrect because he never indicates, one, whether there are any acute type injuries in the employee's cervical spine that could have been caused by the second date of injury, the second alleged date of injury. If you look at the MRI scan that occurred following that incident, it shows only acute findings, and neither Dr. Karimi, Dr. Hunt, of course, Dr. McCarty addresses the shoulder, but none of those doctors address how that type of injury could have caused or significantly aggravated her neck. Now, it's also not true to say that that injury caused her neck symptoms. If you look at the various records, she started treating for her cervical spine in May of 21, prior to her second date of injury. In addition, she also does have a history of a prior neck injury. She was previously diagnosed with a neck bulge, treated for approximately a year afterwards, and noted intermittent periods of dizziness, which she related to her neck injury before her alleged date of injuries at Centracare. So this was a pre-existing condition, and thus the fact that Dr. Simonet finds that there was no injury to her neck, it has proper foundation and support simply from the objective medical records.
I want to ask you about the shoulder again.
Okay.
We have Dr. W's opinion, which was accepted, which says, yes, the 2020 work injury aggravated and accelerated the condition such that surgery was necessary. Surgery is, in one way, shape, or form, a permanent alteration of the body, cutting it open, scraping things out, tying things together. Hypothetically, the employee needs additional care for that specific spot. Is that covered or not covered by the work injury?
That's a good question, Your Honor. I think it's a bit circumstantial looking forward. I think that she would theoretically have the ability to make a claim based on Judge Bateson's findings because he was not specifically asked at the hearing to address whether the injury was temporary or permanent. He had simply said that the injury that occurred had at that point resolved. And I agree with your analysis, Your Honor, which is that you can have an injury that requires cutting and pasting and all that fun stuff that you do, but I would say that it's akin to a broken bone. A broken bone is going to be a permanent injury from the standpoint that you're always going to have that break in the leg, even if it heals, there's going to be that portion in your bone that is permanently affected. But that doesn't mean that you're going to need medical treatment permanently going forward. So a permanent injury
But
can
you might.
resolve. But you might.
Right.
Correct.
Okay.
So, Mr. Micheletti, and again, just to be clear, finding number 51, the last sentence says, medical treatment of the employee's left shoulder after that time, meaning 3 months post-surgery, is not causally related to the February 15, 2020 injury. You don't interpret that as meaning it's a temporary injury or it has resolved. It's just any other medical treatment from February of 2021 through the date of hearing is not related to the work injury.
Correct, Your Honor.
Okay, so you're not saying that means temporary, we'll never ever pay for anything again. It's just that period of time is not related.
Right. I hope we never pay for anything
Okay,
again.
right, okay.
But my understanding of that, Your Honor, is that, as I mentioned before, this is a complex medical case. The employee had a large, or a lot of things going on, 2 different body parts. And my understanding of Dr. W's opinion was that the work injury component of that had resolved by February 19th of 2021. And thereafter, the medical treatment that she had would be relative to her pre-existing and personal condition, not relative to the work injury. In my read of the findings in order, I don't believe that precludes her from ultimately making a claim going forward, but I believe that from the findings in order, at least what we see now, that was a resolved condition. Not temporary, but resolved.
Thank you.
Any other questions?
No.
Good.
Thank you all.
Thank you.
Thank you.
Thank you. We have 90 days to issue our decision. We thank you very much, and we appreciate your time because the oral argument helped us out much this morning. Thank you.
Thank you.
Yeah, you too.
It didn't occur to me that they weren't next to each other. The Court of Appeals don't like sitting next to each
Well, I
other.
told Deanna,
Space out. I guess I thought they were always spaced out. I don't know.
I have seen it that way with one and then a space, and then I allowed them together.
We got tickets, and then we were looking at hotels.
Unless they were set up with
What's happening? So,
Put the chairs out.
For some reason, we have 4 chairs here, so we have 5.
there's no cost. We tried.
Rare piece of furniture now that they can't just order one, they'd have to order all of them.
Maybe.
We did, yeah. There was a party in our neighborhood. Yes.
We don't have to do that.
Almost 6 G, pick off after that time. Yeah, take off.
Just press stop.
Oh, tell me, actually, before you do it.
No, it's on.
Hello? Okay, hang on, let me take a
Make sure
picture.
to stop. Sorry, so just press
Okay,
stop.
okay, I'll take a picture anyway. Okay, that's all right. I was gonna, I want to put a picture in the marshmallow.
Oh, okay.